During the government business session of the Meghalaya Legislative Assembly on the 30th of August 2024, several bills including the Meghalaya Appropriation Bill number 4 were introduced and presented on the floor of the House.
I beg to leave to introduce the Meghalaya Appropriation number 4 Bill 2024.
Motion moved. Let me put the question before the House. The question is that leave be granted to introduce the Meghalaya Appropriation number 4 Bill 2024. Those who are in favor say aye.
Aye.
Those who are against say no. The ayes have it, the ayes have it. The motion is carried and leave to introduce the bill is granted. Chief Minister to introduce the bill, please.
Mr. Speaker, sir, I introduce the bill.
Commissioner Secretary to read out the title of the bill.
The Meghalaya Appropriation number 4 Bill 2024 is introduced in the House.
Now we come to item number 8. Sri Preston Tungsong, Deputy Chief Minister in charge, Parliamentary Affairs, to move that the second proviso of sub-rule C of Rule 72 of the Rules of Procedure and Conduct of Business in its application to the Meghalaya Appropriation number 4 Bill 2024 be suspended for the time being in so far as the rule requires circulation of the bill 4 days in advance before the motion for consideration may be moved.
Mr. Speaker, sir, I beg to move that the second proviso of sub-rule C of Rule 72 of the Rule of Procedure and Conduct of Business in its application to the Meghalaya Appropriation number 4 Bill 2024 be suspended for the time being, insofar as the rule requires circulation of the bill 4 days in advance before the motion for consideration may be moved.
Motion moved. Let me put the question before the House. The question is that the second proviso to sub-rule C of Rule 72 of the Rules of Procedure and Conduct of Business in its application to the Meghalaya Appropriation number 4 Bill 2024 be suspended for time being insofar as the rule requires circulation of the bill 4 days in advance for the motion for the consideration may be adopted. Those who are for the motion say aye. Aye. Those who are against say no. The ayes have it, the ayes have it. The motion is carried and the motion for suspension of the Rule 72 of the Rules of Procedure and Conduct of Business is adopted. Now we come to item number 9. Let me read out the message from the Governor. Dated 27th August 2024. Order. In exercise of the powers conferred by Clause 3 of Article 207 of the Constitution of India, I, Sri C.H. Vijayashankar, Governor of Meghalaya, hereby recommend to the Meghalaya Legislative Assembly the consideration and passing of the Meghalaya Appropriation number 4 Bill 2024. Sri Conrad K. Sangma, Chief Minister in charge, Finance, to move that the Meghalaya Appropriation number 4 Bill 2024 be taken into consideration. Chief Minister, please.
Mr. Speaker, sir, I beg to move that the Meghalaya Appropriation number 4 Bill 2024 be taken into consideration.
Motion moved. I will now put the question before the House. The question is that the bill be taken into consideration. Those who are in favor say aye. Aye. Those who are against say no. The ayes have it, the ayes have it, and the motion for consideration is adopted. Now we come to item number 10. Sri Conrad K. Sangma, Chief Minister in charge, Finance, to move that the Meghalaya Appropriation number 4 Bill 2024 be passed.
Mr. Speaker, sir, I beg to move that the Meghalaya Appropriation number 4 Bill 2024 be passed.
Motion moved. Now let me put the question before the House. The question is that the Meghalaya Appropriation number 4 Bill 2024 be passed. Those who are for the motion say aye. Those against say no. The ayes have it, the ayes have it. The motion is carried and the Meghalaya Appropriation number 4 Bill 2024 is passed.
A half-hour discussion during the autumn session today centered on the Land Transfer Act of 1971 as amended. The discussion was initiated by North Shillong MLA Adelbert Nongrum, with the Minister in charge of Revenue and Disaster Management, Kermen Shilla, providing a response.
Out of answer to question. Mr. Speaker, sir, please allow me to bring up my start question on the Land Transfer Act and the replies made by the Minister in charge, which are as follows. A. Whether the Land Transfer Act 1971 as amended allows for the transfer of land from a tribal to a non-tribal by a lease, deed, the answer given at first instance was no, and thereafter the answer was revised by corrigendum to yes. B. Whether land held through lease by a tribal local director of a company can use the land for setting up and running a factory in the name of the company where he is the local director. Here again the answer given in the first instance was no, and thereafter was revised the answer was revised by corrigendum to yes. C. Whether land held through lease by tribal local partner of a partnership firm can use the land for setting up and running a factory in the name of partnership firm where he is the local partner. Similarly, here also the answer given in the first instance was no, and thereafter the answer was revised by corrigendum to yes. Mr. Speaker, sir, anyone and everyone who has come to know about the striking change in the answer from no to yes that was made overnight will surely understand the first matter I raised in this discussion about the strange flip-flop made by the minister in charge. On the second matter that I raised, that is the answer to be treated as the official response, I would like to discuss them in light of the Land Transfer Act 1971 as amended and other relevant statutes. The official answer to whether the Land Transfer Act 1971 as amended allows for the transfer of land from a tribal to a non-tribal by a lease deed is replied as yes. Let us read Section 3, subsection 1 of the Meghalaya Transfer of Land Regulation Act 1971, which clearly states, no land in Meghalaya shall be transferred by a tribal to a non-tribal, and where in Section 2, Clause D, transfer is defined as the conveyance of land of one person to another and includes lease. Of course, Section 3(1) has an exception which states, except with the previous sanction of the competent authority. But this only implies that no land can be transferred by a tribal to a non-tribal is the norm, and that a transfer made with the sanction of government is the exception. The norms and the exception are the two different factors in law. And how do we know which is the norm? Well, we read the provision of Section 3(1) in light of the preamble to the Land Transfer Act, which state, thus, an act to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribe therein. Mr. Speaker, sir, so it cannot be implied by the official response of the minister in charge that land from a tribal can be transferred to a non-tribal by a lease deed has suddenly become the norm. The reply of the minister in charge therefore sends a wrong signal to both tribals of the state who are protective of their land being alienated, as well as non-tribal outsider who have an eye on acquiring land in the state. As for my start question, B and C, both these questions are similar in that they both relate to the holding of land through a lease deed by the tribal local director in case of a company, and by the tribal local partner in case of a partnership firm. And so I shall discuss these two questions at one go because the legal implication is almost familiar or similar. Mr. Speaker, sir, now Section 105 of the Transfer of Property Act 1882 defines lease of immovable property as transfer of a right to enjoy such property made for certain time, express or implied, or in perpetuity, in consideration of a price paid. And Section 17D of the Registration Act 1908 provides that lease of immovable property from year to year or for any term exceeding 1 year or receiving a yearly rent is a compulsory registrable instrument. Hence, after a conjoint reading of the various provisions of law, it is mandatory for the lease deed referred to in my start question B and C to be a registered deed made with a registration authority in a district and not just by mere registration of the lease deed before the local traditional authority or notary public. Further, it has to be clearly understood that the tribal status of the local director in case of a company and local partner in case of a partnership firm in whose name the lease deed is made is not co-extensive with the company where he is a local director or partnership firm where he is the local partner. In other words, the Land Transfer Act will definitely come to operate in case the local director or local partner use the lease deed made out in his individual name for running a factory in the name of the company where he is the local director, or in the name of the partnership firm where he is the local partner. Mr. Speaker, sir, so the official response given as answer to my start question B and C again cannot be implied to be the norm and maintainable in law, as it is mandatory for the company or partnership firm wanting to use the land for setting up and running a factory to have a valid registered lease specifically in the name of the company or partnership firm. And that too is much dependent on whether the original lease allow for a sub-lease. From my side as a public representative, Mr. Speaker, sir, after receiving the official answers to my start question on Land Transfer Act 1971 as amended, I am now apprised that there is the great possibility that cement factories and coke oven plants and mining operations and even petrol pumps may not have valid land documents as required by the Meghalaya Transfer of Land Regulation Act 1971 as amended and other relevant statutes. Sir, with these very few words, Mr. Speaker, sir, I thank you for admitting this half an hour discussion on matter of public importance arising out of answers to my start question on Land Transfer Act 1971 as amended. With these very few words, sir, I once again thank you and all the honorable members, and I'll resume my seat. Thank you, sir.
Okay. Minister in charge to reply, please.
Mr. Speaker, sir, I thank the honorable member, Sri Adalbat Nongrum, for the discussion. Sir, the Meghalaya Transfer of Land Regulation Act 1971 was enacted by the state legislative in the year 1971. The purpose of enactment of this act is to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribes of the state. The act came into force on the 16th January 1972. The Meghalaya Transfer of Land Regulation Act 1971, Meghalaya Act 1 of 1972, extends to the tribal areas within the state of Meghalaya as specified in Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, subsection 2 of section 1. With the enactment of this act, land in Meghalaya, which includes immovable property of every description, and any rights in or over such property cannot be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority, and any transfer of land made in contravention shall be void and shall not be enforceable in any court. Under Section 2D of the Meghalaya Transfer of Land Regulation Act 1971, as amended by the Amendment Act of 2010, the term transfer has been defined to mean the conveyance of land of one person to another and includes gifts, sale, exchange, mortgage, lease, surrender, will other than will covered by Clause C of subsection 1 of Section 3A, license or any mode of transfer or any authority with the conferred rights upon a non-tribal to use or to derive benefits from the land as an owner. Sir, the Act has various provisions which fulfill the intent of the legislature when it was enacted, and some of the important provisions are Section 3. It mentioned that no land in Meghalaya shall be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority. This section was further strengthened by an amendment as early as in the year 1971 by Act 1 of 1973 by adding a provision which stated that provided that the government of Meghalaya is satisfied may from time to time by notification prohibit any transfer of land within such area or areas as may be specified in the notification, and thereupon the competent authority shall not sanction any such transfer of land under the provision of this Act within such area or areas. During the course of time, this section was further amended by the legislature in the year 1991, Act 11 of 1991, which added another proviso which stated that provided further that no notification made under the preceding proviso shall apply to transfer of land for any of the purpose mentioned in Clause E of or Clause F of subsection 1 of Section 4. Therefore, sir, the two important exceptions allowed by the amendment of 1991 are Section 4(1)(e), whether the land proposed to be transferred is required as a place of public religious worship by any community or as burial or cremation ground. Section 4(1)(f), whether the land sought to be transferred is for the purpose of implementing a scheme to promote the interests of the tribals in the field of education or industry. After Section 3 of the Principal Act by the Amendment Act 2012, the following new Section 3A have been inserted and is reproduced below. 3A1. Nothing is in subsection 1 of Section 3 shall apply to any transfer of land of an owner taking place. A. By devolution and succession according to the personal law governing him. B. By way of partition or settlement amongst the immediate member of his family. Immediate members of his family means lineal descendant and includes husband, wife, mother, father, mother's brother, father's sister, son, daughter, includes stepson, stepdaughter, and adopted daughter and son or daughter of the mother's brother or sister, father's sisters or brother.
The ICFA University Meghalaya Admission Open 2024. The university offers program courses in the schools of management, humanities, social sciences, and science and technologies for both undergraduate and postgraduate programs, UG and PG programs. Full-time campus programs offered under the undergraduate programs are BBA, BCA, BCom, BTTM, BA, Economics, Political Science, English and Education. For PG programs are MBA, MCom, MTTM, MCA, MA, Political Science, English and Education, MA Khasi, MSW and MA Music. For further information and details, visit or contact the ICFA University Meghalaya Shillong Campus, Powerville near Shillong Law College, Dhangati, Meghalaya. Phone number 0364 222 0057, 94851 58603, 700-505-7728, 8794 250646.